lengthy processes on frivolous, vexatious, or otherwise unsubstantiated charges which are devoid of merit. This panel chair was appointed by Speaker, as members will know, after a call for nominations from all parties in the Assembly. It was chaired by retired Constitutional Court Justice Bess Nkabinde, and there were two other members as well, both who are senior counsel, namely Advocates Dumisan Zabeza and Advocate Johan de Waal. The panel did request an extension. They ought to have done their work within 30 days, but due to the volume of documents and the complexity of the matter, they asked for an extension, which was granted by the Speaker, and then ultimately they delivered their report on the 24th of February 2021. This report found prima facie evidence of misconduct and incompetence, and recommended that a Section 194 committee be established to consider and hear the matter. The report, as members will be aware, was adopted by the Assembly in March 2021 and has now culminated in the establishment of this committee. Chair, the slide overview of litigation. As members may be aware, the PP is challenging the constitutionality of these new removal rules in the Western Cape High Court. And this application consisted of two parts. Part A is where the PP sought an interim interdict to suspend the removal process pending a judicial review of the decision by the Speaker to accept the motion. And then secondly, she's also challenging the lawfulness of the removal rules. In respect of the issue of lawfulness, the Public Protector raised 10 arguments, including those related to audi alteram partem, the Latin phrase which means the entitlement to be heard, the fact that in her view there was procedural irrationality, the right to legal representation. The rules don't allow her legal representative to actively participate in the committee, the rule against retrospectivity. This had to do with the fact that these rules were adopted after the conduct in question, issues related to the recusal and conflict of interest, the right to independence and separation of powers. This matter was also heard together with another application that was brought by Democracy in Action, which is a civil society organization, and they raised very similar concerns, hence the two matters were then heard together. The PP was not successful in securing that interdict in Part A, and the legal effect of that is that unless and until those removal rules are declared unconstitutional, the Assembly may continue with its inquiry. Part B, which was on the substantive issues and deals with the actual review of the process and the constitutionality of the rules, was heard in early June of this year. We are still awaiting judgment in that matter, and as it currently stands, we have no indication as to when judgment will be handed down. In terms of the legal framework, the process for removal is governed by two legal instruments: the Constitution firstly, and then secondly, the so-called removal rules. In terms of the Constitution, Chapter 9 heads may be removed on grounds of misconduct, incapacity, or incompetence. In our case, the motion deals with misconduct and incompetence only, doesn't deal with incapacity. Removal of the Public Protector and the Auditor General requires a finding by a committee of the NA and a supporting vote of at least 2/3 of the members of the NA. So it's important to note here that the threshold for removal of the Public Protector and also the Auditor General is higher than that of other Chapter 9 heads, which just require majority vote. And it's clear from the certification judgments that the incumbents have a special protection because of the nature of their roles, which often involves the investigation of high-level officials and controversial matters, which of course may have adverse political consequences. As such, the removal threshold is therefore higher. The President may suspend the Public Protector, and that's entirely at his discretion, at any time after proceedings of this committee has commenced. but must remove the public protector if the NA so resolves. Chair, I just want to mention that the basis for removal, so incapacity, misconduct, and incompetence can obviously only be properly understood against the backdrop of the Constitution and the Public Protector Act. And that's because sections 182 and 193 of the Constitution sets out this unique role that the Public Protector plays in our constitutional dispensation and the requirements to hold such office. Also relevant would be section 195 of the Constitution, which sets out the principles of public administration. So when the committee starts unpacking the evidence, it will be necessary at that stage to first have a briefing on the role of the PP, as it will directly inform whether her conduct meets the threshold for incompetence and misconduct. So in other words, members would need to acquaint themselves with the standard of conduct that is required from a person holding this office. In respect of the removal rules, those rules were adopted by the Assembly on 3rd December 2019. They define the terms incapacity, incompetence, and misconduct, and they provide the broad procedure to be followed. Firstly, the tabling of the substantive motion with evidence, the sifting mechanism by the independent panel to establish if there's prima facie evidence, and then this committee process to conduct an inquiry if the Assembly so determines, which in this case it has. From the Constitution and the rules, whilst they may not be prescriptive, they don't tell the committee how to perform its task. And this, Chair, is with good reason. The rules are not unique to the Office of the Public Protector, nor are they drafted to particularly deal with this motion. The same removal rules are going to apply to any other Chapter 9 head in respect of whom a motion for removal is brought. And of course, the basis for removal will differ greatly from one Chapter 9 head to another, and even from different heads who may occupy the same position. Thus, it's left to the committee to determine, with due regard to the nature of the charges and the specifics of the matter, how it will determine its working arrangements going forward. However, whilst the rules and the Constitution are not prescriptive in terms of how the process unfolds from this point, they do provide the outline of the steps to be followed for removal, and more importantly, the fundamental legal principles that must underpin the work of this committee. It's these principles that will need to inform every decision of the committee. I've termed them golden rules, and this is my own term that I've coined. And these golden rules are, in effect, the blueprint of the process. They are in place to ensure that the process is fair, that it's balanced, and that it's beyond reproach. The first rule is that this process is a constitutional process. And Chair, I'm at pains here to emphasize that this committee is not conducting a criminal inquiry, nor should it be seen to be such. This is not a judicial process, and it's not a litigious process. As such, the rules that would apply to criminal processes, such as evidentiary burdens, admissibility of evidence, and so on, don't find effect in our process now. They are of no application here. The process is instead ultimately an oversight process. Indeed, it does have a political element in that it will culminate in a decision by the Assembly, which of course consists of members of political parties.